So we'll just go ahead and dive in. First, by way of questions, if anybody has any questions, you can plug them into the Q&A in your little dashboard there. Spencer from my office is also part of this presentation. He's going to be monitoring that for me, and so he'll interrupt me as we go with any questions that you have. So I'll start by just introducing myself a little bit. My name is Joseph Jones. I'm a cyber investigator. I started my career as more of a traditional private investigator, doing all the gumshoe type things. But around 2010 or so, I realized, and this is still, social media was still fairly new on the scene then, but I realized that social media had really major implications in the investigations world and in the intelligence gathering community. So at that point, I kind of pivoted my career and really started focusing on social media and cyber. And that's been the main focus of my personal caseload and, my efforts in the last, whatever that is, 12 years. At the time, I found that training for investigators who in the private sector who wanted to learn about this kind of stuff was almost non-existent. So I went to a couple of organizations that train primarily government operatives, Department of Homeland Security, FBI, CIA, in how to operate in the social media and cyberspace. And I basically took all of the tools and the tactics that they were teaching and figured out how to apply them into civil litigation, which is really where I live. So as we go today, we're going to cover a lot of different things. Hopefully, you're going to find it really helpful. Again, if you have any questions, put them in the Q&A there. So the title of the presentation is Ethical Evidence Collection and Use. So the ethics portion of it might be a little bit different than what you're thinking. Certainly, we are going to talk about some ethical considerations, things that you should do, things you shouldn't do, things that are a little bit gray area. But especially for those of you who are attending this from California and are part of the California bar, really what that means is that we are going to cover a couple different aspects of the rules of professional conduct and talk about how they relate to social media evidence, social media investigations, and the like. So first, rule point 1.1, it has to do with competence. If you, as an attorney, are going to engage in any practice of law, you've got to do so competently, and that extends beyond just what you're specifically doing, and really any part of your case that you're touching, including investigations that you're having done, information that's being collected, evidence that's being collected. And oftentimes I see attorneys, when it comes to social media evidence or cyber evidence, I see a lot of attorneys who have this concept of like, oh, I'll have the intern do it, or I'll have the paralegal do it, or I'll have, my nephew who's a college student do it. And that can be really problematic for a lot of reasons, which we're going to cover. Another thing that I see come up, a fair amount is when, especially with older attorneys, when they're thinking about social media investigation, they're either personally not on social media and so they don't understand it, or B, they just think about Facebook. Right. So here's some statistics here that show you, at least, some of the top platforms here, user statistics. There are billions and billions of people who are on social media and active users posting constantly. And so, it's important to remember that today in 2023, that Facebook no longer is the king of social media. Certainly, they've got a lot of users. There's still a lot of content that we get from there, but it has been a long time since that's been the the primary mode of social media that we're getting our evidence from. You've got Instagram, TikTok, Snapchat, Twitter. There's literally hundreds of these platforms out there that have so much information that can potentially be of relevance and of interest to your case, regardless of what type of case you're working on. We do work really across the board. What I often say is, if you have questions about the parties or the issues in your case, there's a really good chance the answers are somewhere on social media. Another thing to keep in mind that's really important as we're talking about acting competently within the social media space is that the landscape is ever changing. What is relevant today will probably not be relevant, at least in the same way, in 3 to 6 months. It's a moving target. It can certainly be very frustrating, but that it is what it is. And so one example of that, back in so let's go back to let's say 2018. The typical way that users would get content on social media is they'd look up the account for the individual, they'd look at the account, they could see the timeline of everything that had been posted for the last how many ever years. In 2019, that changed, and it changed because of a trend that Snapchat started with what's called stories. This is self-deleting content that is oftentimes only live for 24 hours or less. And Instagram introduced stories sometime, I want to say it was around 2018, about 2019. For Instagram, stories outpaced the traditional posts. So that's a major shift, and now it's kind of spread to the rest of social media. That's a significant shift when we're talking about investigation for litigation purposes, because stories are self-deleting, right? So it's harder if I get retained the week before trial starts to do a really thorough investigation, because there's a possibility that there's been content that's been posted and deleted for the last several years while litigation has been going that we can't see because it's already gone. So that's one of them. Also, a lot of the systems and softwares that law firms or the big box investigation companies use for social media investigation, they don't have the ability to grab anything off of stories, and so you've got just like this massive amount of data and potential evidence that's getting totally left on the table. But bottom line, social media is here. It's here to stay. It's been here. It's not going away. It's not getting smaller. It's only becoming more pervasive in our lives. And I've read more than one article in legal publications that essentially assert that if you as an attorney are not utilizing social media as part of your standard protocol as you go through cases, that you could be committing malpractice, because there is so much information that is potentially case changing. It really has to be checked. All right, so back in the early days when I first started doing this, there was very few investigation agencies, very few law firms, very few people were really thinking about social media back when Facebook just came on the scene. Now it's much different. It's very common for a variety of case types for that to be part of the early on kind of intake process. But what I've seen as the popularity of doing this kind of investigation has grown, is that the amount of nonsense that happens and the amount of reports that are being generated from like Lexis type databases are becoming a standard. and they're not a very good standard. If you're interested in having it done completely and having it done in a fully I'm drawing a blank on the word I'm drawing for here, competent, in a fully competent way. So here's a couple bullet points on why that is. A lot of these database, kind of driven reports that maybe you're getting, or maybe are trying to be used against you in your case. Here's a few issues with them. They have serious foundation issues because they are database driven. They have serious authentication issues because they're being pulled based on basically computer input with very little review on details pertaining to the account and the account holder who's actually posting versus who's pictured in the profile image. No forensic preservation, no preservation of the self-deleting content that we talked about. No or very little information from family and friends who, again, there's so much, and we'll talk about that more, there's so much that can be gathered from family and friends, and no reviewing of hidden or deeper than public profile content, which is especially important when we're talking about how can privacy settings be legally navigated. So that's why kind of some of the industry standard stuff is highly problematic. So I'm going to, this slide here kind of outlines the path for a lot of the next steps of the presentation. We're going to talk about why and how I see social media content getting disallowed in trials on a regular basis. And then we're going to talk about how to address those issues and how to make sure that your content is going to be, admissible in trial. And, usually the, kind of the standard thing that happens is I will get a call from a new law firm who either found us online, they, got us through a referral, whatever, that they'll say, hey, we are getting ready to start trial in a week or 2 weeks, and we had this piece of social media that we were planning on using in trial, and we just realized we've got some foundation issues, some authenticity issues, or otherwise we were in trial, we tried to present it and the judge wouldn't let it in because of that. And so, what can you do to help us make sure, we're able to use this? So the 4 things that we see regularly that are the cause of evidence being disallowed: foundation issues, authenticity issues, the content not being properly preserved and hashed, AKA people are using screenshots, or issues that arise pertaining to when the photo was taken versus when it was posted. And so we're going to cover all 4 of those and probably a little bit more. So first, and this one I won't spend too much time on this because we already kind of talked about it and I don't want to beat a dead horse. But as we're talking about collecting evidence efficiently, we found that social media has made, and this is one of the things that prompted me back around 2010 to really hyper focus in this area. We find that social media can help everything else be so much more efficient. I have up here surveillance as like an example. We can use social media if we've got a subject that we're going to be doing surveillance on, we find that the social media can help us be so much more effective in our surveillance. We can potentially know where they're going, what they're doing before they go, or at least have a good idea so we know the right time to show up to actually see them out and about, so we're spending less time sitting on a curb, trying to figure out somebody's schedule. We use it a lot when we're investigating medical providers. We're looking for doctors' reviews, and we're looking for connections. I had a case recently, I forget, I want to say it was somewhere in the Midwest, maybe it was Oklahoma, Kansas, I don't quite remember. but it was a case where the issue at play is there was that state had something. It was some sort of a family law case, and they had something called like a friend of the court, which is supposed to be essentially like a disinterested third party who comes in kind of is a mediator to help the judge better understand, kind of the facts and what's going on with the case and make some recommendations. Well, our client, the one who hired us, had suspected that there was a pre-existing relationship between opposing counsel and the friend of the court. And so they hired us to figure out, if we could get to the bottom of what was going on, because they felt like the information getting presented to the judge was heavily slanted, in favor of the other side. So we were able to go through social media and find, not only was there a relationship, but they were neighbors, they were friends, and like they were on social media, they were joking all the time about things, and there was even some like discussion of prior cases on social media. And so that was really interesting, and became an important part of our client's case to get that situation resolved. That same thing with like witnesses. It is not uncommon for us to be doing an investigation, trying to figure out, all right, these witnesses, especially on the eve of trial, witness list comes, we don't know who half of these people are. Who are they? What can we find out about them? How are they connected to the other side? And again, there's a lot of scenarios where you can get very valuable data and information from social media. All right, so back to preservation and authenticity. All right, so the first thing that you need to understand, and like if there's one thing that you take away from this course, is that print screens and screenshots should be and are, if anybody does the research, inadmissible as evidence. There's a lot of case law on the issue. I've got on my website, boscolegal.org, there's like a resources tab that I summarize a bunch of case law regarding this, but I've talked about one here, Moroccan Oil versus Mark Anthony Cosmetics, that talk about why screenshots are inadmissible. So Moroccan Oil versus Mark Anthony Cosmetics, trademark infringement case. Moroccan Oil is suing Mark Anthony Cosmetics, and the major part of their case has to do with this Facebook account that is identified on the account as being a Mark Anthony Cosmetics page. And there's lots of use of the term Moroccan Oil, which is a trademark belonging to the company Moroccan Oil. And so that's what the case about. And they produced a lot of these Facebook print screenshots or printouts from Facebook showing this information. And so one of the things that was really at issue is Mark Anthony challenged the authenticity of all of these posts, and essentially saying like, hey, anybody could create an account that looks like it's ours and post whatever they want. You've got to be able to lay a foundation. You've got to be able to prove that we're the ones that were making those posts, and just a print screen is not sufficient, and the court agreed. There's a wide body of case law on this. There is also a federal rule, which I don't have it cited here. I really need to update the slide to include it, but it was Federal Rule of Court 19 something or other. I'd have to look it up later. But ultimately, what it says is that in order for digital evidence or social media evidence to be admissible, it has to be properly preserved and the metadata extracted from it and hashed, which we're going to talk about that in another couple of slides. But print screens are inadmissible. One of the questions that will get brought up often and frankly should be brought up if the other side hasn't done, proper preservation, is how do you know an account wasn't hacked, or it's not a fake profile, or somebody has edited it? And if all you have is, a piece of paper that shows, an image with a name, like that could be faked really easily. And it is oftentimes done. I will talk about it maybe a little bit later. A lot of the work that I'm doing currently centers around tracking down fake accounts and online bad actors, because this really happens. And it's an incumbent on the individual who's presenting the evidence to be able to, authenticate and lay that foundation. A big part of laying the foundation is really just like the typical easy stuff. Who found it? When did they found it? How did they find it? What were the privacy settings? All of that sort of thing. All right. So now let's talk a little bit in more depth about collecting the evidence and what that proper preservation and authentication looks like. So first, and I'm assuming most of you probably already know, but I'll describe it to be safe. So metadata is very important here. When we're talking about this preservation and collection and hashing process. So metadata is ultimately going to be the computer code, as it pertains to social media, the computer code that sits behind what you're seeing on the user interface. The computer code tells your computer what to display. And so there's really important pieces of information there. One really important piece of information is the user ID. So the user ID is going to be a unique, identification number that pertains to a specific account. That user ID does not change regardless of what the user does on the account, whether they change their photo, their display name, their user handle, that doesn't affect the user ID. And frankly, the user ID, most people don't even know that it exists because it just sits there in the background. And that's a really important piece of metadata to have because it helps us determine it's necessary to determine who's actually behind the account, but also linking posts to an account, right? Because theoretically, I'll share a case example from several years ago. I was working. It was a political thing. We got hired by a guy who was a politician, a local sort of thing. That somebody had started distributing flyers that showed what appeared to be Facebook posts from him that were saying really incendiary things. We're talking really bad about immigrants and all sorts of things. And he came to and that this starts getting around and everybody wants his head on a stick. And so he comes to us and he's like, hey, this wasn't me. Like, yes, I know it looks like me and it looks like my account, but that absolutely was not me that said those things. So he got hired. We got brought in to try and help, kind of figure it out. One of the things that we were able to do in that case to really, resolve that issue pretty quickly is analyze the user IDs, right? Because the user ID of one, the user ID of the other, if they're not the same, it's not the same account. And it's really easy to steal somebody's photo and name and create an account that looks like it's theirs. So that user ID is very important for that exact purpose. Another thing that is important to do to authenticate an account, and this is part common sense, part technical, following case law, et cetera, et cetera. But Tienda versus State of Texas was one case that early on that talked a lot about this. Basically using specific indicia on the content that's posted on the account to verify authorship. So, for example, what some of that would look like and some of what we're looking for when we have an account that we think belongs to the subject of our investigation, certainly, does the name match, does the photo match? But also, are there known, are they using a user handle that they've used on other platforms? Are they friends or followers or have connections on that account with people that we know they are personally attached to? Are they posting content that is specific information that only they would know? Every account we get, we have to initially look at with suspicion, because it could be a fake, right? So we have to go through and check off some of those boxes. And this is really important, and this is something I see attorneys make mistakes with all the time, that just one or two of those things does not necessarily make it real, right? So I'm working on a case right now out of Florida where my client is an individual, very attractive woman who has repeatedly had people steal her photographs and photographs of her children and from her business, and create fake accounts to lure people into scams, right? Poor guy thinks he's got this, really attractive woman who's interested in him, but she, after a month of chatting, she's like, oh, well, I want to come visit you. Can you send me a couple grand for the plane ticket? Sure. Then, then they're out of the money. So if I was to go and look at these accounts and only go off of like one or two things, I could be duped myself, because these bad actors, they do a really good job of making it look legitimate. And so that's always question number one. How do you even know this is the subject's real account? Because just the name, just the photo are definitely not enough to authenticate an account. All right, so now let's talk about the metadata. We've talked about a little bit kind of what's involved. Some other, in addition to the user ID, other information that's contained within the metadata that might be helpful is going to be your who, your when, your where of the post. And there's all this data in there, which some of it you can see on the user interface, but keep in mind that what you're seeing on the user interface is only a reflection of what's in the metadata. And sometimes, and I'll show you an example later with things like date, sometimes the user interface doesn't even show you the date. It'll indicate like 2 days ago or 5 years ago, but it doesn't give you the exact date. But the exact date is actually contained within the metadata. So that all has to be extracted. There are manual ways to do it, but anybody who's doing this professionally uses some sort of a software that will extract that. And then the next piece is it has to be hashed. So, and there's a couple different hash, algorithms that are being used for the purposes of social media and what we're talking about. Really, there's a variety of hashing processes that work just fine. The idea of the hash is that you're taking the metadata and you're creating a digital fingerprint with it. So the other side, opposing counsel, if they doubt the authenticity of what you're presenting, or if they believe it's been altered, they can inspect it using the same hashing algorithm to determine if any data has been changed. So that's what the hash is. It's basically a digital fingerprint that can be double checked. Now, another thing that can be done to authenticate counts, and we often do this primarily only when we're dealing with fake accounts, or if we're dealing with accounts where there is not enough on the user interface to help us, put together that, that specific indicia to say, for sure, we know this comes from this person. The next step, if that can't be done just from the user interface, is going to be to obtain the IP addresses for, the account holder. IP addresses is basically a street address, but on the internet, right? And that's what helps us figure out what location, a particular, action was taken from. So all social media platforms log the IP addresses that the users are using. And so what can be done is we can, issue a subpoena to whoever the provider is, and in response to that subpoena, we will get a list of IP addresses that were used. Based on just the IP address, by itself, I can figure out what city it was in and what the internet service provider is. And then from there, I have some internal resources that we can run it through to see, who does, who belongs to that IP address, or who has used that IP address in the past. If it hasn't been logged into any of my systems, and it gets logged into my systems 100 different ways, but if it's not in there, then we have to issue a subpoena to the internet service provider, Charter, whoever it is, and get the physical address that they were pumping the internet to on that particular date and time. That process can be a little complicated. It's going to require a judge's signature, a court order. It can be a little complex, but it's absolutely doable, and that's how we can, determine exactly, what address a particular, a particular account is tied to, or particular post are tied to. Okay, Spencer, do we have any questions yet that need to be addressed?
No, there's been no questions so far.
Okay, very good. Then we will continue on. All right, rule 3.4, fairness to opposing party and counsel. Lawyers can't suppress evidence. They have a legal obligation to reveal and produce. Also, attorneys have a duty to preserve any evidence that would be relevant to the case whenever litigation is reasonably foreseeable. You guys know all that. Now, the thing that I see ethical violations regularly with has to do with social media. It's important to know that in today's day and age, social media posts are just as relevant of evidence to be preserved as are the business documents. The photos of the, the incident, the emails going back and forth. It must be preserved. Now, whether or not the other side through discovery can get those out of you is a whole nother issue, right? That's a separate issue, and that's something that the last couple of years I've been doing a lot of consulting on some of those issues. But you've got to preserve. So the days of telling your clients like, hey, go get rid of your social media, clean up your social media, going through it with them and saying, hey, this has to go, like that has to stop, because there can be really severe consequences to that. Social media is evidence. It's got to be treated like evidence. A really interesting case, Lester versus Allied Concrete out of Virginia. In this one, tragic accident. A woman died as a result of a car accident, collision with a concrete truck. Goes through jury trial, massive jury award. Then it comes out after the fact that there were a variety of social media posts that were deleted by the plaintiff. And it was found that it was done at the direction of his attorney. Specifically, that the attorney, so there was a request for production that came in for social media. And The attorney tells the paralegal, the attorney pulled up the Facebook account apparently, and told the paralegal, hey, tell the client to clean up their their social media account. So the client goes and deletes several photos, and then they don't get produced. So this comes out. Jury award gets reduced by over $4 million, and the plaintiff and his counsel have to pay $700,000 fees, expenses, and sanctions because of this deletion. And this is, this one I think was especially severe because the instruction to delete came after a request for production. So there was just no claiming dumb. But in today's day and age, it's going to be really hard for attorneys who have instructed their clients to delete social media content to, it's going to be hard for them to play dumb, because ultimately it's out there. So another part of this, and and I realize client control can sometimes be an issue. So at a minimum, attorneys need to be advising their clients in writing. Well, you're the attorneys, you decide how you're going to do it, but consider doing in writing to your clients, hey, you can't delete any of your social media. To kind of insulate you, at least some, if that happens without your knowledge.
All right, we got two questions.
All right, what do we got?
One is, does it work? Like, can you obtain IP addresses overseas and get IP addresses from internet cafes?
So both good questions. So getting the IP address for something overseas, absolutely we can get it, because all like the servers where that data is going to be kept, assuming it's on social media, is going to be, at least any of the major players, is going to be housed here in the United States, mostly all in California. The issue that you're going to run into, and I have a case right now that we're grappling with this issue. So we found that our bad actor is overseas, and so we know their IP address overseas. We know what their IP address they're using, but it's not logged in any of the systems that I have. So we have to go to the internet service provider to figure out physical address. And because they're overseas, if we want to keep pursuing that case, we're dealing with a whole different ball of wax, because domesticating something out of the country can be, depending on the country, can become quite difficult. So it does become very complicated when it gets overseas, and typically the only time that we would have a case that we'd continue pursuing overseas is when the stakes are going to be really high. On the second issue, if it's an internet cafe. So yes, but there's also complications, right? So it's not incredibly difficult. I can get that IP address and I can trace it back to that internet cafe. The issue is, once it traces back to that internet cafe, what can I do with that information? And the answer is, it depends. So if it's, and I just wrote an article, well, somebody else, like from my agency, wrote the article, and I tweaked it up. You might want to look at about the Darrell Brooks trial and the the fake juror who posted, trying to derail the trial, where I talk about this issue, kind of in depth. But ultimately, if it's like a Darrell Brooks sort of issue where, we have the information now, it just happened, and we can hop on it quickly, especially if we have, law enforcement cooperation and I can get them to pop off some search warrants really quickly, then we can go and get video surveillance from the coffee shop to at least see who was there that day, because they're going to have a lot of people. If it's the kind of scenario where, it comes back to a coffee shop and this happened 2 years ago, now it becomes a much more difficult thing. However, this data, this IP address data, especially from social media platforms, is not going to be limited to just the IP address from the date that I'm interested in. It's going to give me all logins and all logouts for the entirety of the account. So typically in a scenario like that, we say, all right, the IP address on the day of, bummer, it comes back to a coffee shop, but I can go back for the last, couple of years and see what other IP addresses were they using. And a lot of times, unless you're dealing with a really sophisticated bad actor, a lot of times when we go through that process, we're able to find, hey, at one time they were logging in from their house, even though it wasn't on the date of the incident. Also, those records that we're getting via subpoena they also have phone numbers, email addresses tied back to them. And so that's other ways we can, use those records to, figure out who the bad actor is. So hopefully that answers the questions.
All right, we got one more.
Yep.
What's the process for extracting metadata or preserving social media for a witness or opposing party? And then can anything be done or any metadata recovered once a post is deleted? Okay,
so first, what's the process like? So we use softwares to do it. So, for example, if you were sent me right now, an Instagram post, hey, we think this is going to be, valuable to our case. It shows X, Y, or Z. Can you get it preserved? We will just go to the post right now. We run it through our system. It extracts the metadata, gives us a copy of what the user interface shows, and then hashes it. So we've got it. Our deliverable, it's we put it in a PDF. It shows what you see on the user interface, date, date and time information, and then the hash value. And then we retain all of the metadata on our servers, because you don't want all the computer code. It's not going to mean anything to you, but we do have it preserved for trial. So that's what the process looks like. These softwares are commercially available. There's a variety of them out there, which if you're interested, you can shoot me an email after the fact and we can talk. But ultimately, I typically advise attorneys or paralegals against doing their own preservation, because if it does go to trial, not only are you going to need to have that piece, you're going to need to be able to lay a foundation. And an attorney or a paralegal cannot testify in their own trial and lay the foundation for their own evidence that they've collected. For the second question, what do we do about metadata collection on something that has been deleted? So we could talk about that for like half an hour, but in short, the full metadata typically cannot be recovered after something's been deleted. However, we can usually recover, well, I don't want to say usually, how in the circumstances where the deleted content can be found, we can recover at least some of the key pieces of metadata, and at least the image of what once was. I will say, when we get the request, hey, we think something's been deleted, it's a 10 to 20% chance we're able to recover something that's been deleted. And typically we have to know what we're looking for. We can't, if you just say, hey, here's person A, tell me what they deleted. It's, it really doesn't work that way. Okay. So hopefully that answered your question, and I will be providing at the end my contact info. So if anybody has follow-up questions, feel free to reach out. All right.
One more.
Yep.
How can you extract an IP address for Gmail accounts? I have found that the IP address is static for all users. What can be done to obtain authentication information?
Yeah. So emails are kind of a whole different thing, but very similar in the way that they operate. So certain email services, you can go through the header data. Well, all email services, you can go through the metadata that's associated with that email to extract an IP address. The issue is, as I don't know who asked that question, but the person who asked that question, what the issue is with Gmail is Gmail, they mask the user's IP address. So they have it on their servers, but on the public facing header data or metadata that gets sent out, it contains the IP address for Google server. So from that point, from the metadata within the email itself, you're not going to be able to get the true IP address for the user. So that's going to have to be obtained by subpoena. Or there is another methodology that we can use. So that's typically the way that we'll do it, and we do it all the time. And it's very similar to the ways social media subpoenas work. Although, small caveat, if any of you tried to subpoena social media, Gmail, whatever, it's very difficult. There's, once you get the process down, like we do it and it goes super smooth, but you have to be very specific in what you ask for. You also have to be very familiar with the Stored Communications Act and what you can and can't ask for. Side tangent. So I'm jumping back to, Gmail. So if I'm trying to trace emails, where an email was coming from, who's really behind it, it's going to involve that subpoena to Google to get the IP addresses and then tracing it. There's another thing that can be done where we can set up, and there's lots of different names for them, but basically, like I refer to them as tripwires, where we can send an email to the bad actor email address that I'm trying to get their IP address, and when they view that email, it's going to pull their IP address and send that to me. So it's a way to kind of circumvent that process. You can't use it all the time, especially if you're like in litigation already, and this person, they've already been named, but if they've got counsel, now you've got a problem. If they don't have counsel, maybe you're okay. And we'll talk about that a little bit more in a few slides. But hopefully that answers that question. Okay. Oh yeah, so going to this ex-parte communication issue, we can chat about that now. So rule 4.2, communications with the represented party, the ex-parte communication rule, everybody knows, if somebody's represented by counsel, the attorney or their agents can't communicate with that, with that person. So early on, like, people tried to say, like, oh, just viewing somebody's social media profile because there could potentially be, some sort of a notification, like on LinkedIn, that's an ex parte communication. That didn't hold water for very long, and I don't see that argument anymore. That just viewing it is an ex parte issue. But where the question can come in is on private profiles. If you find somebody's profile and it's set to private, and you try to friend request them or follow them, is that an ex parte communication? There's a couple things to talk about, and certainly, like, there's situations where maybe it can be done and be ethically admissible, but those situations are very few and far between, and they have to follow a very kind of specific path. As a general rule, the answer is that you should not, if somebody has a private profile, you should not friend request them or follow them if they're represented by counsel. Again, the caveats we're not even going to cover here because they're very few and far between. One interesting thing, though, is that there is, so Richards versus Hertz is one case, and there's a lot kind of in the criminal arena, a lot of case law on this issue. This is where people have gained access to private account. Private, I put in quotations because there's no such thing as privacy on social media, really. But where content has been obtained from private accounts, and it has been deemed admissible as evidence. The courts have ruled again and again and again that there is no expectation of privacy on content posted on social media, because once you have posted that, you lose control of where it goes, even if initially you said, I only want it for my friends. We're running a little short on time, so I'm not going to dive into this issue a whole lot. But one of the areas that that this comes up a lot for us is when we're dealing in cases where it's either not in litigation or a party is unrepresented, and this is a lot with our tracking down online bad actors, where we are able to engage with them under false pretenses to help uncover their true identity. And so again, we're short on time, so I don't want to belabor this one, because it's not it doesn't come up a lot. But the question that does come up on the daily for us is, what do you do about private accounts? Let's say you go, you've got a Instagram account for the subject of our investigation. Let's say we're, in the middle of civil litigation, and we see that they've got 2,000 posts. And so we know there's a lot of stuff there, but they're set to private. How do we, what do you do about that? Well, the answer again is that privacy on social media is a fallacy. And although without, being able to follow them would be great, because we'd be able to see it very, very easily. But if we're in litigation, that is not the go-to tactic. But the friends and family are the go-to tactic. And what we find, case after case after case, even when our subject is set to private, their friends and family aren't. And it's important to remember that social media is a social thing, and the user only has control over what they post on their own page. They don't have control over this content that they post on their friends' pages, or the comments that they leave on their friends' pages, or the photos that their friends post of them. And so all of that is a great way for us to still be able to obtain evidence and information about individuals whose accounts are set to private. And there are a lot of these techniques that we can use that really help shortcut us finding this, this type of content, right? So for example, and these are just, I've provided some example Boolean search operators here, which you can kind of look at. I won't belabor too much, but for example, I'll just talk about this third one. So Joseph Jones in quotation, the near 15, and then quotation private investigator. That's a Boolean search operator that is telling a search engine, I've got this guy named Joseph Jones that I only want the name if it appears just like that, who's a private investigator. So I want my search only to be for that term. And then this near 15 tells the search engine, I want those two terms within 15 words of each other. So that really cuts very quickly into looking for content specifically pertaining to me. And depending on the platform that they're on, depending on what they've posted, whether they've posted in groups or not, we can use some of these Boolean search operators just within to Google to find content that has been indexed from the social media platforms. So even if it's not, viewable, right on their profile, it can be got because it's been indexed another way, or they've posted in a group or something. We can, again, talking about, the importance of metadata. We were able to find out, and it was a change Instagram made a while back. It was frankly great for us that in the metadata on a private Instagram account, through the metadata, even if it's private, we can figure out who their followers are and who they're following. So on the user interface, it just shows you the number, but going through the metadata, we were able to find, hey, here's the actual list. So we know which friends and family that we can look at to try and find that content. One tip that you guys can use if you're doing some of your own preliminary poking around here is we find that people are creatures of habit. And so if you have an email address for them, and for example, surferdude123@hotmail.com, there is a good chance that surferdude123 they are using as their handle on their social media as well. All right. So this is kind of the last thing that I'll talk about. It's case study. This is a case that that we worked and I ended up testifying on. I want to say it was 2018, but it gets to the heart of one of the big issues that comes up a lot, having to do with how can you tell when a photo or a video was taken as opposed to when it was posted. And the issue is, so when we do this metadata extraction from social media, all of the major social media profiles, they write over the original photo metadata. So like this photo, as it was uploaded to Facebook, Facebook stripped out the original metadata from that and applied new metadata that really only will tell us the date that it was uploaded to Facebook. And so this thing comes up a lot, like, all right, like, yes, all right, cool, you guys did your preservation, you can tell us when it was posted, but how do you tell us when it was taken? So that came up in this case. This was a personal injury case, and and I testified, this is public record now. My client has given me permission to share these photos and talk about this this case. So this individual here on the jet ski she's involved in, or she was involved in this litigation, and one of the things that was became a big deal was her ability to ride jet skis. There was testimony by her and her family that it's something that she could no longer do, that her injuries were too significant, etc. So in this case, we had done the investigation, and our client had presented, while the individual was on the stand, presented them with the copies of the Facebook post that we found and said, hey, isn't this you? And and isn't this the date that you did it? And she'd answered, yes, that's me, but indicated that those photos and that video were actually taken before the incident and just posted afterwards, which is, it is something that can happen, and it does happen, but B, that's, it's a great way to keep evidence out of court, because it gets kind of to some of the foundational issues. And so when that happened, I was brought in to explain how we actually knew the date that the photos were taken. And so I'm going to walk you through quickly. We've only got a couple minutes left, and so I'll walk you quickly through how we were able to do that. So on this particular subject, she was very active on social media, and so we were able to analyze her habits. And we found that her primary mode of posting is that she posts in the moment. And when she does post older content, she will qualify it as being old, giving kind of the narrative about, either hashtag TBT, which means Throwback Thursday, back in the day, this is, I did this thing, etc. So that was part one. Part two is we looked at the language and the actual comments and the context surrounding these photos and videos, which is really important to do. And as we did that, we found, you'll see that she indicated that it was her first time riding a jet ski, which, again, to her point, could have been, I'm posting about when I did this, however long ago. Although, again, based on her use, generally, like, she's not the kind of person that would post an exciting event 3 years later. She would do it, that day, the next day, etc. But later in the comments, there was another comment that she made. Well, she said, well, that was my first time writing by myself, but today I was writing again and I got this. And so by using the word today, she, allayed all doubt about when it was. And she had said it was that today she was writing again. Also, interestingly, you'll see in the comments, it only has a 3Y. It doesn't have the actual date, but the metadata showed that 3Y was August 13th, 2016, the day after the post. So it all lines up perfectly. And then she also geotagged it, which is the last one that shows there. Then there was some other contextual factors. That weekend was the daughter's birthday party, the geotagging. But lastly, we were able to pull up the registration with the DMV for this particular vessel, and we were able to find that the vessel was purchased and registered after the accident in question and just a few months before this photo was taken. So that's a one case example of how potentially you could date when photos were actually taken as opposed to when they were posted. Another thing that we can do is certainly we can get the original photo and check the EXIF data on that as well. Okay, so that is the end of my prepared remarks. I'm happy to hang around for a couple minutes if there's any additional questions. Here is my contact information. Feel free to reach out to me if you have any questions, or if there's anything else that I can do to help you understand this crazy world of social media and cyber evidence.
All right, we do have a couple questions.
Okay.
First is about VPNs. Does it truly hide their IP address? Can you discover someone's IP address if they're using the VPN? And do you have to subpoena for that?
So, if somebody is using a VPN, it makes it much more difficult. It doesn't make it impossible, but it makes it much more difficult. And subpoenas will definitely have to be part of the equation. Definitely, maybe there's a 1% chance if they're using a VPN, we're able to trace it back without going the subpoena route. It is, if somebody's doing it the right way, they're using the right VPN services, they can make themselves invisible and untraceable. Especially if we're talking about civil litigation. If it's a case where I can work with law enforcement and we can make stuff happen real fast, there's a better chance of tracking them down. But one of the issues, the VPN services, they know the real IP address, and they have it on their servers. The real issue you're going to run into is they're going to have real fast turnaround times on their deletion of that data. So if you're 2 years after the fact, the likelihood that that data still exists is very, very low.
Okay, how do you authenticate text messages?
So text messages are going to be a lot more straightforward. Typically, you can get the device that it's from and do an extraction from the device, and that shows the phone numbers. If it's a case where they're alleging some sort of like spoofing or something, now we're talking about a whole different ball of wax, and let's talk about that specific question offline, because it's it gets pretty complicated. But it's kind of the same preservation process, except you just do it from the device or a backup from the device.
Okay. This one was when you were talking about friend requests and you mentioned engaging with them under false pretenses. Isn't that pretexting, which is prohibited under state and federal statutes and.
So context on that is everything. Pretexting in and of itself is not illegal. There are certain types of pretexting that are, like pretexting banks or pretexting utility companies. That's definitely illegal and is a problem. But again, context is everything. Right? If it's civil litigation and you're in the middle of litigation and you're trying to pretext somebody who's involved, you've got problems all day long. If you're trying to identify a bad actor, then it's going to be a little bit different. Also, the types of information that you're trying to obtain through the pretext matters, right? Finding the identity of an individual and using those links to get their IP address is on the right side of the law. Doing that to get PII, like their date of birth, their social security number, big no-no. And so again, context is everything. Now there are in a lot of those kind of cases, we're working on either before an attorney has come into the case or sometimes after an attorney has come into the case for a client. One thing to keep in mind there is an ethical obligation that attorneys have not to mislead. However, there is an exception when fraud is involved. It's rule professional conduct, I want to say 8.4. I can send it to you if you hit me offline about it. But again, when we get into engaging with bad actors and using pretext, it's a very sensitive area. So it all depends on the case.
All right, and last one, it says, what about Twitter comments? And so I'm assuming if they're wondering if we can find if an individual made comments on posts. And
yeah, if that's the question, can we find comments that a Twitter user has been making on other people's pages? The answer is yes. And of all, if they've been deleted, of all the platforms, Twitter is going to be one of the easier platforms to find deleted content. I'm not going to say it's easy, but compared to some of the others, it's more doable with Twitter than with others.
all right, that's the last one.
Okay. Well, thank you all for having me. And again, feel free to reach out if you have any questions.